atheists, agnostics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government, hug the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Northern Kentucky University political scientist Michael Baranowski. I'm joined today by my, once again, not conservative counterpart, Professor of Law at Chase Law School, Ken Katkin.
Hey, it's great to be back.
Yeah, it is. And I am looking forward to getting to some of the things that we didn't have time to discuss on the regular show. I always, whenever, on the rare occasions that you and I get to do the podcast together, I always try to focus on as many legal things as possible to take advantage of your legal expertise, because, of course, you are a resident constitutional law scholar here, literally, on this show. And it's always a lot of fun for me. And one of those stories I wanted to talk about had to do with, another legal expert, another conservative legal expert, and that's a retired federal judge, Michael Luttig. And of course, the reason I want to talk about him is because ever since the Supreme Court agreed to hear an appeal of Colorado's ruling that Donald Trump is ineligible for office, amicus briefs had just been pouring into the Supreme Court. And this last week, Judge Luttig filed one of these briefs. And he's not just some guy. I mean, he has some serious conservative and legal credentials. I mean, he was a White House counsel in the Reagan administration. He was appointed to the Fourth Circuit by George H.W. Bush. He was there from 91 through 2006. The guy's got some serious legal chops, widely respected in the conservative legal community. At least he was prior to speaking out against Donald Trump after January 6th. Now, I had a chance to review his brief, and in it, he does a number of things, and I'll just kind of lay this out, and then we can talk about it, Ken. He makes first an argument that he believes should be convincing to a majority on the court if they hold to the textualist interpretive principles that they've cited so often in the past. And he, in fact, writes that it would violate the rule of law on textualism for the court to essentially create an off-ramp to avoid adjudicating whether or not Donald Trump is disqualified from running. I mean, he's not buying the argument that the court can claim that, well, the president isn't an officer of the United States and therefore is not covered by the insurrection clause, as a number of people have suggested that the court might do. And I think maybe I'll stop here before we get to the rest of Luttig's arguments. What do you think about that? Because that's certainly, I mean, there's been a debate about whether or not the president is technically an officer of the United States. What do you think about that as a way for the court to sort of get around actually having to rule on this?
Well, I do think the court is going to use an off-ramp of one sort or another, despite, Judge Luttig telling him they shouldn't. But I think that they would probably, the kind of naked argument that the president is not an officer of the United States is ridiculous. And I don't think a single justice would subscribe to that. What I think you might see is a variant of that some justices would subscribe to, where they would say, well, although, of course, the president is an officer of the United States, he and the vice president are the only ones who are elected, and all the other officers of the United States are appointees, either in the executive branch or judges. And I think they might say that the true meaning of the clause is that applies to appointments and not to elected officers. So I think that's a plausible off ramp if they want to find a way to carve out the presidency. It's not a textualist approach, right? Because they would be reading the word officer. They would just be reading in the word elected officer. But I think that's a more plausible approach than to say, well, he's not even an officer. I mean, that's outrageous. How could he even give a military order as commander in chief of the army if he wasn't an officer?
So in other words, if people want to elect an insurrectionist, that's okay, but they just can't appoint one.
Yeah, I think that would be an argument. I mean, that's what I take to be the substance of the argument. This technical argument about whether he's an officer or not, I think is a sideshow, because he obviously is. But I think if you want to credit that kind of argument with having any substance to it, it's not on the technicality of who's an officer or not, but it's on the relationship between Section 3 of the 14th Amendment and our democracy, right? That the basic idea is that, people who are trying to end our democracy, shouldn't be able to do that. But elections are part of our democracy, right? So, that's more paradoxical. Like to say, well, people shouldn't be able to elect someone because we need to save democracy is more paradoxical than saying, well, nobody who's trying to end our democracy should be appointed into a situation where they can end our democracy.
Now, there are a number of other arguments that Luttig makes about why the court shouldn't dodge this issue. Another one, and he disputes the argument that, well, states don't have the power to essentially rule on a presidential candidate's qualifications for office because Section 5 of the amendment, the 14th Amendment, says Congress shall have the power to enforce the provision by appropriate legislation. And Luttig's point here is that, well, just because Congress has the power to enforce by appropriate legislation doesn't mean that the states have no role in this. It seems to me more of kind of like a federalism argument, which on the face of it should appeal to a majority of the justices, I would think.
Yeah, I mean, one of the paradoxes for me is that I agree with, I guess, well, let me just put it this way. I'm not a textualist. I'm not an originalist. Luttig is those things. And we have, most of the conservative justices on the court who claim to be those things. And I fully agree with him that if you think that textualism and originalism are the only valid forms of constitutional interpretation, that text can best be read the way Judge Luttig is reading it. The best reading of the text is that generally, state governments are always under an obligation to comply with federal law. State courts are always under an obligation to give effect to federal law, and that includes federal constitutional law. And the fact that Congress has power to legislate on a subject is neither here nor there to the question of whether state courts have to enforce the Constitution directly. I agree with all that. I do have a little bit more sympathy for non-textualist interpretation, and I think here, to my own mind, it is actually a good political principle that would be reinforcing of democracy, that decisions of this magnitude should be made at a federal level. I actually think it would undermine democracy a bit to say that, any state or local official or even state Supreme Court can just decide to disqualify candidates from the ballot because they declare those candidates to be insurrectionists. I think there's room for quite a lot of political abuse there. One of my favorite, I would say, non-textualist cases is the term limits case. I don't know if you and I have talked about that one before.
I think we might have, but I'm fairly familiar with those. But go ahead.
Yeah. So the term limits case, in case the listeners don't know it, which I think is correctly decided, but it's essentially a non-textualist case. It addresses the question whether states can impose term limits on U.S. senators and U.S. members of Congress. Right. So the U.S. Constitution doesn't do that. And in Arkansas, the voters actually, by ballot initiative, amended the Arkansas state constitution and said nobody can go to the U.S. Senate or the U.S. House from Arkansas for more than 12 years, and then they're done. And that gets challenged at the U.S. Supreme Court, and it's a 5-4 case. And all the textualists and originalists on the court join Justice Thomas's dissent, which thinks that Arkansas can do that because there's nothing in the Constitution that says that they can't. But the majority by Justice Kennedy says, well, actually, there's two separate opinions. There's a Stevens opinion and a Kennedy opinion. But between the Stevens and the Kennedy opinions, I think the commonality is they say, well, even though it's not spelled out in the words of the Constitution, the structure of the Constitution really requires that there be separate lines of privity between each voter and each government. So, I'm a citizen of Ohio, and I'm also a citizen of the United States. So as a citizen of Ohio, the Ohio government is a government of the people, by the people, and for the people of Ohio. It's directly constituted by me, responsible to me, has jurisdiction over me. And meanwhile, the same is true of the United States. The United States is a Republican form of government. I'm a citizen of the United States. The United States government is a government of the people, by the people, and for the people. But the key to this majority opinion is that the states are not merely bureaus or departments or branches of the United States government, but neither is the United States government merely like a compact between the states. They're just independent governments that are in direct privity with the voters and that are not, they're not able to structure each other. And so the court holds in the term limits case, Arkansas can't tell those United States citizens who live in Arkansas who they can elect to the United States government. They just can't interfere with that relationship between the citizens of the United States who happen to live in Arkansas and the government of the United States. And I think those kind of principles are really good structural principles. I do believe structural interpretation is a good form of interpretation. And I would probably be more sympathetic to deploying that here and saying, we actually can't allow state or local governments to play that big of a role in interfering with who the citizens of the United States who happen to live in a state can choose to elect to the United States government. That those kind of decisions or responsibilities have to be federalized, and so that some responsible federal official should have to declare that Trump is disqualified before he could actually be disqualified. And that would match the practice that followed the Civil War, because after the Civil War, it was the Defense Department, although it was then called the War Department, that was issuing lists of people who were disqualified by Section 3 of the 14th Amendment. And so that was a responsible federal agency issuing those lists. I think, I wouldn't have any problem with a ruling that uses that off-ramp. I think that's actually a valid off-ramp. But what Judge Luttig points out is that if you're a textualist and originalist, then that's not a valid off-ramp for you to use.
It occurs to me, as you were explaining that, it occurs to me that under sort of that understanding of the Constitution, the 10th Amendment, the states' rights in this matter, that a state could presumably pass a law saying a ballot access law saying that if in the view of our state you are really anything, because there's no limiting principle in the Constitution there, if states are allowed to add requirements for eligibility, it would be pretty easy to ensure that certain disfavored candidates don't appear on the ballot in your state, which would be
that's my point. Yeah. That's why I think the term ruling is correct, right? I mean, under the Thomas dissent in the term limits ruling, the state could have added any qualifications that they wanted to. So in that case, the qualification was that you not have already served for 12 years. But, if the qualification was, well, you're not a member of the Democratic Party, we're not going to add you to the ballot if you're a member of the Democratic Party. I think the Thomas dissent in term limits says, well, states could do that because there's nothing in the Constitution that says that they can't. And I think the better rule is the majority's rule, that the states cannot interfere with the privity between the voters that happen to live in that state and the United States government.
And I should point out there's one more argument that Luttig makes about the court not dismissing this in one way. He talks about the political question issue, and he says this isn't that because he argues that there are, in fact, judicially manageable standards by which the courts can determine if someone has committed insurrection. And I love how he makes this point, kind of taking a shot at the court. He said, listen, it's easier to determine whether someone's an insurrectionist than, to decide on whether equal protection applies in vote counting like you guys did in Bush versus Gore, which I thought was kind of a little shot there. But what do you think about that argument?
Yeah, I fully agree with him that the court should decide the case. I think there's more paths where they could decide it in a way that overrules the Colorado Supreme Court. But I think the political question doctrine, although the word sounds to most people like they're talking about this is just politics, not law, the usual actual technical legal meaning of the political question doctrine is that the courts shouldn't decide questions that are supposed to be decided in the other federal branches of government, which are sometimes referred to as the political branches. So, in this week's regular show earlier this week for the listeners, earlier today for us, you and I were talking about the Judge Walter Nixon impeachment case. that was a case where the political question doctrine applied. And what the court said is, well, an impeachment trial is a trial, but the Constitution places responsibility for the conduct of that trial in the U.S. Senate. U.S. Senate is part of the Congress. That's part of the legislative branch. That's one of the political branches of the government. So if there's a trial-like proceeding, normally those things take place in a court. But if the Constitution says that this particular trial proceeding has to take place in the Senate, then that means that the courts don't have jurisdiction over deciding whether it was done right or wrong, that the Senate gets to decide that. And I think that kind of political question doctrine would have no application to this case because the other branches are not implicated at all. It's really a state court. Political question doctrine doesn't apply in federalism cases, basically. It only applies in separation of powers cases where the argument would be the court should stay out because this is something that the Senate's supposed to decide, or the court should stay out because this is something that the White House is supposed to decide. But there's no concept that a similar doctrine could ever apply where the court should stay out because this is something that states are supposed to decide. If states are supposed to decide it, then the court on the merits should rule that states are supposed to decide it. They shouldn't just stay out of the case.
Thanks for listening to this Politics Guys interview. If you're not already a supporter of the show, I hope you'll consider becoming one because without our supporters, we wouldn't be able to do this. And when you become a supporter, you get not just that warm, fuzzy feeling knowing that you're supporting a good cause. I like to think we're a good cause, but you also get stuff like ad-free versions of everything we put out. You get our supporter exclusive midweek show, the full length of that, not just the preview. And you also get to be part of our Discord group if you want. And there's always some interesting conversations going on there. At the $10 a month level or more, you get to actually be part of the episodes Jay and I do, if that's something you're interested in. So there's a lot of stuff is what I am saying. And I hope you'll consider checking it out. And to do that, just go to patreon.com/politicsguys. If you want to support us on Venmo, we're at Politics Guys. You can also support the show through PayPal. And all of our support links are always in the show notes, as well as at politicsguys.com/support. And as always, I want to close with a very special thank you to our wonderful executive producers, Bruce Johnson, Wilma Moreno, Daniel Toe, Ryan Beasley, and Don Oglesby.